Absolutely. Good morning, Your Honors. Manuel Martinez for the petitioners.
And confirming that you're requesting 12 minutes and 3 for rebuttal, correct?
I am.
All right, thank you. And then appearing for remotely for Mr. Sandoval, Real Party and Interest.
Good morning, Your Honors. Chad Morgan on behalf of the Real Party and Interest.
All right, thank you very much. And your time estimate is 15 minutes?
Correct.
Right, thank you very much. Mr. Martinez, you may proceed.
Thank you, Your Honor. Honorable Justices, Counsel, may it please the Court. The California Public Records Act provides access to the business records of a government agency, but not to the personal private emails of its employees. This boundary is being challenged today. The novel question before this Court is whether or not the district, in response to a Public Records Act request, must search for, seize, disclose the personal private emails of its employee.
So you've used the phrase personal private emails twice now.
Yes, sir.
And so help me understand your definition of that, because as I understand it, we're talking about email that was generated and transmitted using a district, not only hardware, but email address.
Thank you, Your Honor. That's an important point. I think the definition of what a business record is versus a personal private email comes to us from two important sources. And it also comes from the facts on this particular case. First, we look to the statute, the definition of a public record. Government Code Section 6252, Subdivision E. It requires several elements, that it must be a writing, that it must be about public business, that it must be owned, used, or retained by the governmental agency.
So let's talk about public business.
Absolutely.
Then.
Yeah, and I think that's where we transition off to the California Supreme Court. In the San Jose case in 2017, interpreted that exact statute and said, in order to qualify for public business, that those records have to be necessary and convenient to the discharge of that official's public duties, official duties.
I'm sorry for the interruption, Mr. Martinez. My understanding of the language from City of San Jose, though, is generally any record kept by an officer because it is necessary or convenient to the discharge of his official duty is a public record. I don't read that as laying out a requirement so much as an observation. Would you like to explain why I'm wrong?
I would, Your Honor. I wouldn't say that Your Honor is wrong. I think Your Honor is focusing on one piece of that point, and maybe if I can kind of also illuminate some of the further readings from the San Jose opinion. The court in that same kind of general area of the opinion also said that public records need to be looked at in the context. It needed to be looked at with their content. You needed to look at to whom the audience was. You needed to look at the subject matter. All of these factors go into explaining why the record has to be the public business of that entity, and for important reasons, Your Honor. I think what the
would you concede at least, and again, I apologize for the interruption, but would you concede at least that Oasis as a public charter school, that as a publicly chartered school, that emails relating to Oasis business are relating to a matter of public business?
I would concede that as of 2020. I think what kind of was in our briefing was that, and this kind of goes into away from public records law to charter law. Charter schools are creatures of statute. The Charter Schools Act was created in 1992. From 1992 to the year 2020, schools were not subject to the Public Records Act. They were not subject to the Brown Act. They weren't subject to the Political Reform Act. I'm sorry.
So Mr. Martinez, even if we were to concede that, even if we were to agree that Oasis itself wasn't necessarily required to comply prior to 2020, when we're talking about whether the subject matter is the public's business, I mean, I think that's what we're looking at. I mean, nobody's suggesting that this demand was made to Oasis. It was made to the Hartnell Community College District. And I understand that your view is that, because it's not the district's business, that you can't be responsible for it. I appreciate that that's the distinction that you're drawing. But you, if I'm understanding your argument today and your briefing correctly, your position is that it's not even that the emails we're talking about are not even related to the public business of the charter school because of when they were generated.
No, I don't think we're saying that at all, Your Honor. I think to kind of clear the ambiguity on that, these emails absolutely had to do with Oasis, had to do with Oasis business. That business statutorily became subject to the PRA in 2020. I think the point of that, I think, frankly, an important point from the perspective of charter school law and then kind of transitioning it into the Public Records Act, was simply to illustrate that at the time of the request, we're talking about 2018, 2019, at the times of the request, that these records didn't even meet the definition of a public record as to Oasis. But I don't think that the court even has to decide that issue in order to reach the ultimate conclusion here of overturning the order down below. I think what's important, kind of walking the path of San Jose, is that the San Jose court was confronting a situation where it was asking itself, how do we deal with public records that are not found on a district's, or in that case, the city council servers? What do we do? And in that situation, the high court laid out a path. It said, for all instances where you have records that are not within the government servers, we're going to walk this path. We're going to have the governmental agency at issue connect with its officials or its employees, ask them to seek out those records, fill out an affidavit, come back and tell us how you did it, and then we can process and balance several important interests. And I think that that's kind of where it is, because at the heart of the Public Records Act is transparency to the public.
Exactly, and the Public Record Act also talks about public records, regardless of who owned them or who generated them, about who retains them as well. Would you agree that to the extent that they're on the district servers, they are retained by the district?
Retention is not an issue. We fully acknowledge that those records are on the servers. But I think in addition to what I was about to say there is, while public transparency is at the heart of the California Public Records Act, that heart also contains important constitutional rights to privacy, important federal privacy rights that come down from FERPA. So when
those privacy rights relate to the personnel file, not necessarily to the emails that Mr. Navarez, in his capacity as an official of Oasis, and also to the extent that he's using the district's email address and email servers in his capacity as an employee of the district, is freely and voluntarily corresponding with Mr. Sandoval. So what's the privacy interest there?
Absolutely, right. I think that the record is showing a deeper, much deeper acquisition of information than just correspondences with Mr. Sandoval. You see a declaration from the president/superintendent of the college saying that those records, about 1,500 pages worth or documents worth of communications, reflect personnel records of Oasis, potentially attorney-client privileged communications with Oasis, student records, which are protected by federal law implications. So you have personal privacies implicated by the constitutional right to privacy and Government Code Section 6254 Subdivision C.
But your position, if I'm understanding correctly, and again, I apologize for the interruption, your position is that none of those emails, regardless of the content, should be disclosed. That the district has no obligation to turn over any of those emails that were generated by Mr. Navarez in his capacity, in his sort of dual capacity, basically, relating to Oasis. That none of them are subject to disclosure, not because of privacy interests, but just because it's just not your responsibility.
I would amend what Your Honor says. I don't disagree with what Your Honor says, but I would add to it that these records are not to be disclosed from Hartnell, that Hartnell is not in any position to weigh the privacy interests of OASIS personnel, OASIS students.
And doesn't the
OASIS
statute lay out a procedure by which you can consult with OASIS?
I'm not aware of whether the statute requires any kind of consultation with OASIS. I think that's...
I'm not suggesting that it requires it, but it does anticipate the circumstance where another agency may be implicated, does it not?
I'm aware of that part. I don't have it off the top of my head precisely what subdivision it is, Your Honor, but I think that envisions a different kind of relationship. I think it envisions a relationship similar between perhaps like a law enforcement agency and the Attorney General, where they have a commonality and legal privity, and you have two separate legal entities who are on the same mission or providing somewhat of the same essential public function. I think that's the context of what that particular law is talking about, not something where you have two foreign entities, and I don't mean foreign in terms of extra, out of a different state or something, about like you have an elementary school and you have a community college. One is educating children and young little ones, and the other one's educating adults. And
Two agencies that don't have any natural connection or relationship with each other.
yes, Your Honor, and I
But
think
they're
in that...
both public. But they're both public. So my question to you is then what's the solution? If Hartnell is not the one who's supposed to be disgorging these records, then how is the public's interest protected?
That's an interesting point, Your Honor. I think that not only is the public's interest protected by asking the respondent to go to OASIS to seek these records, but also the fundamental constitutional privacy and federal privacy interests and attorney-client privilege interests that are implicated by the request are also solely within the purview of OASIS, not anybody else. To ask, and I think this kind of speaks...
So what would happen if... I think I'm just envisioning a number of situations, given your solution here, that involve, the internecine battles between various public agencies. Your client is retained, Hartnell has retained the records. You're not disputing that Hartnell's has them and is obliged to retain them. So then what if Hartnell says no? And how would OASIS even access them?
So I think that goes exactly to the 2017 High Court opinion in San Jose. So number one, in the San Jose court, at the back end of its opinion, laid out a very robust plan to say when you have a situation where government agency documents are not within the government agency, we're going to walk this path. We're going to have the public officials search those repositories, fill out an affidavit, and come back. And that's not a process that was unique, or divined by the San Jose court. This is something that the San Jose court was looking at, either the state of Washington and some other states that have gone down the path ahead of us in terms of the age of electronic.
So I'm sorry, in this instance, who would be filling out the form?
Well, in this instance, if you apply the San Jose reasoning,
Right?
the respondent would have gone to OASIS, would
Right.
have made the request of OASIS. OASIS would then evaluate to who are the custodians of these records, would have identified not only one board member, but potentially other board members, and then would have worked independently with them to say, you have an obligation to cooperate with us, give us these records, fill out an affidavit, and then those records get processed.
But at heart, isn't part of the San Jose reasoning to ensure that the public's business won't be transacted via private mechanisms that are then not subject to disclosure because they're not housed or generated in that case the city's server, and how is that even analogous to what's going on here? It seems here that you have the opposite situation. You know where the emails are generated and retained, and so there's nothing preventing someone to go right to the source and say, I'd like those public records.
That's an excellent point, Your Honor. I think that's why this is a question of statewide importance, because it's the first step of saying, well, hey, wait a minute. Again, at the heart of the Public Records Act is transparency, but equally within that heart are all the other privacy interests that belong to everybody else. The Public Records Act doesn't favor one over the other in the sense that it says one prevails at the cost of the others at all time. There's an analysis that gets applied, and they do battle, and sometimes the public's interest wins out, and other times the privacy interests play out.
But the burden, wouldn't you agree, is on you to establish that the privacy, where the privacy interest is at issue? And I appreciate that you're not saying that it implicates all of the emails that are subject to the request here. But even where it's properly raised, isn't the burden on you to establish that the privacy interest should override?
Well, in this particular instance, that's exactly my point. The answer is no. That it is not with Hartnell. It's with Oasis, because these are Oasis children, Oasis employees, Oasis business. We have no context. We have no understanding of the form or who these individuals are. We couldn't contact them if we wanted to say, hey, if you'd like to file a reverse CPRA like in Markin, go right ahead. We have no ability to do that.
So it's not just, it's partly it's an issue of who should bear the burden of having to do that review and so forth. You're also saying that as a practical matter and as a legal matter, there could be liability for Hartnell if you were to attempt to stick your fingers into the pie of Oasis documents that are currently being retained by Hartnell.
Absolutely, Your Honor.
Okay.
And to Justice Grover's point, who or why would we just not, have Hartnell, just if the public wanted to go to Hartnell and say, give me these records, I would argue cut out the middleman, go to Oasis. That's what San Jose said.
Well, but how is that burdensome to Hartnell? To just say, oh, we've got this request, which appears to implicate potentially some of these interests that aren't held by us, they're held by Oasis, and you notify Oasis of that.
So that is a very important question, and there's two important responses as to why that's burdensome. Number one, we get hundreds of these, if not thousands of these throughout the year. I'm just telling you, my practice, I am up to here with Public Records Act requests from a variety of entities. So that's issue number one in terms of this mass kind of spider web of communications.
May I ask, of those thousands, what percentage present this situation where they're not Hartnell's, not records that Hartnell actually created, owned, generated for its own business, but implicate another agency's?
It's hard to answer because sometimes you get unsophisticated requests, right? We get requests from lay people, right, non-attorneys. We get requests from attorneys. We get requests from out of state. I get bombarded from Texas, Louisiana, and Tennessee, New York. We get bombarded from a variety of sources. Generally speaking, for the ones where we say, I don't even know what you're talking about, help us help you, they'll either abandon their request or they'll just move along. So it's hard to tell if we were the correct entity that they were looking for or not. I think to answer that, if I made the second point of why this would be burdensome, is that just because Hartnell picks up the phone and says to Oasis, hey, this is something that you ought to do, the hot potato's on Hartnell's desk. Hartnell is now at risk of legal fees, is at risk of being right here in front of you, right? I mean, the only reason that I'm here is because somebody didn't ask Oasis, and that's my client is spending resources for me to be here because for whatever reasons the request didn't go to Oasis, and for whatever reasons Oasis isn't being invited.
I think you're here because you were asked and you declined to provide the records.
We did, and that's fair. I'm not shirking that at all, but I think at some point my client is trying to sort out the fog of the judicial opinions. This is a novel area. This is something that's difficult. Mm-hmm. And with my client's policy of allowing, de minimis use on their computers, that's another issue of statewide concern. Since the age of technology has developed over the last decades, right? The Public Records Act was written in the 1960s and has evolved to today. But technology has evolved much faster. We have information on our wrists, we have information in our pocket, information that blows away former concepts of a file cabinet or a desk. It's mind-boggling as to where that information is popping up. And the law is kind of behind that evolution, and we're trying to figure out what is the best way to proceed.
But doesn't technology make it actually easier in most cases to find that information? If it's something that's retained electronically, you do a search for keywords as opposed to literally going to a storage unit, going to Iron Mountain and retrieving documents, looking through file cabinets and having various departments and individuals search for paper records.
It does, Your Honor, but that's step one. Then all of the privacy interests, right? When we put it on the legal advisor's hat and say, okay, we found these documents, what do we do with them? Oh my gosh, they're talking about student information. Somebody's being expelled, somebody has a disability, somebody has an allergen, somebody's getting a divorce, somebody has a custody issue. All of those privacy interests are foreign to Hartnell. Somebody's talking about litigation. I don't know who or what they're talking about. They're talking about an acquisition of a property. They're talking about molestation and terrible, terrible things. I'm not saying or suggesting that those are in here. I'm just illustrating the point that once you find them, and I agree with Your Honor that technology does allow for us to find things, but it's be careful what you ask. You ask a question, you get an answer. You find a treasure trove of confidential information that we are in no position to weigh, and those are important, critical privacy interests, constitutional interests that have at least should have the right to be equally vetted with the public's right to know by somebody who has a better sense of what that is.
Well, and also to insulate you from liability.
Yes, Your
I
Honor.
I take your point to be partly that were you to release records under the CPRA and do so in a way that violated a student, a teacher, somebody's right to privacy, then Hartnell would be sued.
Yes, Your Honor, and it goes. I don't want to be dramatic, but we represent educational agencies. We see situations similar to this, the matter that was before my matter was called, where you have custody issues, and custody issues aren't always polite and they're not always safe. And so knowing what that information is and what the potential outcome of that information desperately needs a person to know who are we talking about, what are the dangers that are involved, what are the liabilities that are involved. All of those important issues are of statewide concern if local agencies, and let me pause for a second, the Public Records Act was written for the entire state of California. There are local agencies that do vastly different things. Cemetery districts, water districts, city councils, counties, hospitals that are subject to the Public Records Act in some way, shape, or form. And to require or impute some sort of responsibility to say, simply because if you had an employee who may be volunteering or doing work on behalf of some other entity, that information is obtainable vis-a-vis some mechanism under the CPRI by a different unknown entity.
But it does go to Hartnell's policy. You've made reference to de minimis use of district email. So, I mean, that's a policy and a personnel decision by Hartnell or whatever affected entity it is. If you say, hey, you work for the government, this is a public computer, this is a public email server, do not use it for any business other than our entity's business.
So there's two responses to that, Your Honor. I also represent, I negotiate against unions, so I also represent my clients on that. So you're speaking to my heart in that sense of saying, I wish I could say that and it'd be that easy. Number one, you have a past practice and pattern that developed well before the San Jose case, that developed long before this concept of applying the Public Records Act to our devices in our hands. I would argue there's probably a lot of information that is within the walls of this court where folks are volunteering for one thing or another, and it's like just because some information happens to be on a phone and somebody walks into the court, does that now make the court somehow, transmutes them into a vehicle by which access to that information is available? That's what I'm concerned about. And so when you say that, is that the effect of the policy? Number one, it's hard. It's hard to manage people and to say, this is forbidden fruit. You cannot use or on your own break time or on your own lunchtime look up articles, send out an email or two or something like that. And so the policy is a reflection of reality more so, and not necessarily to say, and by the way, we're going to subject these emails to public disclosure. I think that there is a balance. I think that the San Jose court gave us a roadmap to follow. I think that roadmap, by keeping things strictly with, or keeping the request strictly with the entity that is receiving the request, is workable. It doesn't require this court to develop a new rule. It doesn't require this court to set new law. It simply requires the respondent, who was well aware of who he was asking, well aware of the school. He had children in that school. He participated in that school. He litigated against that school. He knew who that school was. Nothing prevents that individual from simply going to the school.
So getting back to,
No, go ahead. I'm just
I'm
going to
sorry.
mention that we're significantly
Well,
over time, but when justices are asking questions, we continue the argument. Go ahead, Justice Lee, please.
I appreciate that, Justice Greenwood. Getting back to your discussion with Justice Grover about the burdens of this falling on you, falling on Hartnell in this particular instance, you've acknowledged that from the standpoint of pure acquisition of the records or pure retrieval of the records, that may be made easier by technology, but that all of the other, policy issues and application of policy to the particular content at issue, that's the burdensome part. So I just want to follow up on that. To the extent that the statute does permit the entity the agency that receives the record to consult with the other agency. I recognize that you've indicated before that that Hartnell's relationship with OASIS isn't that close of a relationship, doesn't really facilitate that kind of communication. But from a policy standpoint, in theory at least, Hartnell could, once they've retrieved that volume of that universe of emails that are responsive, turn that over to OASIS to identify what it is that they're claiming is privileged. Could they not?
They could, Your Honor, but I think there's a lot off the table in your hypothetical that also should be discussed. So yes, they could go through that, but I offer another scenario. Although Hartnell can pick up the phone and call OASIS, Hartnell is unable to say, and by the way, here's the liability. Hartnell can also not shed itself from the responsibilities of getting the redactions right. So we have Hartnell spending blood and treasure redacting, figuring out, and consulting on business that has nothing to do with them. And multiply that out by how many of these requests if you find a situation. And again, when you have an unhappy respondent that says, wait a minute, I think you got it wrong, I'm going to challenge, which is well within their rights. I'm not afraid of standing in front of a court and explaining and defending our decisions. But it's difficult when those conversations and that liability has nothing to do with my client. That's hard. That's difficult because we are being expected to look at 1,500 documents and weigh these important privacy interests, and we're footing the bill. The code doesn't anticipate that. So Your Honor talks about this possibility of reading that into the code as saying, well, that's an opportunity to talk to them. But Your Honor, I respectfully say that you have to look at the entire code and the entire intent, and also look at the cases that interpret the code and say, well, wait a minute, because there's such a heavy motivator on the back end, meaning if you get it wrong, you got to pay the attorney's fees of the other side, and because the San Jose court and other courts, San Jose didn't come up with this. It was quoting Coronado, it was quoting the pilot commission. It specifically said in Coronado, not every document that is in the possession of a public official is a public record. Again, that's where the quote that the San Jose case was coming from in terms of saying that this information needs to be both necessary and convenient to the discharge of the public official's duties. that was a quote that the San Jose court was quoting to from cases from years ago, because this concept was always viewed as that requests were coming to the individual that was at issue, always coming to the governmental agency that was at issue.
So let me ask you this, and I know we're short on your opening time and going to give you some rebuttal time. But,
Yes, ma'am.
but what if a member of the public goes to Oasis and says, you know, I would like these emails about this particular transaction or what have you. So why doesn't the San Jose decision then apply there to say who has the obligation to seek these out and find out that Mr. Navarez was not using Oasis hardware and software, but rather was doing this in his Hartnell position?
I'm a little confused, but let me attempt to answer it, and please tell me if I'm not getting it right. I think that the San Jose case absolutely does anticipate and actually favor and instruct us to have the requester go to Oasis. Oasis would then talk to Mr. Navarez and say, give us our records, since whatever records you may have operating outside of the Oasis system.
How do they know that?
Well, they are in privity. First of all, in this particular case, I think the request implicated Mr. Navarez. So Oasis would know that they would have to go to Mr. Navarez. But even if they didn't, if it was kind of like, and again, you get these very broadly written requests, right? The law already puts a burden on the governmental agency that the governmental agency must seek all known repositories and custodians of records that might have these records, okay? That comes from the Sycamore case, the case that came out of San Diego, where the court was wanting to make sure that all repositories were looked at and the records were obtained. I think that's a little bit different. In fairness to the government agency, it doesn't require that every pebble be turned over. That's not the standard. The standard is a reasonable search. So as long as Oasis was reasonably aware of Mr. Navarez, they would then go to Mr. Navarez. Spoiler alert, he was a part of the request, so they knew that they would have known in this hypothetical that Mr. Navarez was part of the request. And it's up to them to work out those issues, and they can shift among themselves liability. That's, again, this is well-settled law. There's no need to create new law in order to effectuate that scenario. I think I've answered a lot of questions. If I may just,
I think so.
I will sit down. Thank you. Your Honor.
Yes, thank you very much. You'll have an opportunity in rebuttal to respond to Mr. Morgan, who's been waiting very patiently. You can tell that we have a lot of questions in this area. Mr. Morgan, you may proceed.
Thank you, Your Honor. And if it may please the court, I'd like to start briefly with the threshold question of the timing of Hartnell's petition here, a jurisdictional question that, if answered the way I think it should be answered, would moot the rest of the discussion. And here,
You know what, Mr.
Hartnell
Morgan?
received a-
Mr. Morgan, I'm going to stop you. This is going to disappoint you. I think it would be better if you addressed your comments to beyond the jurisdictional question. We're very acquainted with the arguments that you've made in terms of jurisdiction, but I think the court's interest probably lies beyond that at this point, without, having made any determination about jurisdiction. But we understand that argument well. So
Absolutely. I will move on to the question of the Oasis emails.
thank you.
And as kind of the first point, counsel has talked about the de minimis use of Hartnell resources by its employees, and concerns that this so-called de minimis use would trigger obligations under the Public Records Act. At the same time, we're told that there's over 1,500 emails. That doesn't sound like de minimis use. And on the question of whether the records relate to the conduct of the public's business, there's the issue that has been discussed extensively already as they relate to the conduct of Oasis's business. But this also raises questions about the conduct of Hartnell's business and whether its policies allow, whether its policy allowing de minimis use of its resources has been violated here by Mr. Navarez conducting business on behalf of Oasis while using Hartnell's resources, perhaps Hartnell's time. He's being paid valuable public funds by Hartnell to do important work for them. But how much of his time on Hartnell's clock is being spent for Hartnell as compared to how much of his time is being spent for Oasis? And disclosure of this body of emails and that work is important to evaluating how Hartnell is managing its resources. In that context, these records are neither personal nor private emails. They are public. And as the court has noted, San Jose is wholly inapplicable here and completely opposite to the question presented, because San Jose considered the emails possessed on an employee's private personal device. And those devices are neither private nor personal as they relate here to Navarez and his use of Hartnell resources. Looking to San Jose, counsel mentioned some of the factors to consider: the context of the emails, the content of the emails, the audience of the emails, the subject. All of these factors weigh in favor of a conclusion that these are, in fact, public records relating to the conduct of the public's business, wholly in line with the Public Records Act itself, and the plain text of the definition of public records. From the very beginning.
Mr. Morgan, let me just stop you here for a moment. Let's just assume that these are public records. I think as you could see from the questioning we were directing to Mr. Martinez, much of what we were asking about is the use, using the CPRA to access public records through the district as opposed to doing it through Oasis. And I think that's the question before us, really. And tell us your thoughts about why, for instance, it wouldn't have been simply satisfactory, as Mr. Martinez suggested, to go through Oasis itself rather than making the request through the district.
The first point on that is that a public records requester has the right to request the public records from any local agency that is required to disclose them. I would submit that they could have been requested from either Hartnell or Oasis. My understanding is that he did request them from Oasis in the first instance, and Oasis said Hartnell has them, go back to Hartnell and get them. That's not in the record, but looking broadly, if Hartnell has them, Hartnell must disclose them. If Oasis has them, Oasis must. As a matter of practicality, Hartnell has them. It seems most practical to me to go directly to the source. If Hartnell possesses and retained the records, why use Oasis as a middleman to get what he is entitled to request from Hartnell?
Well, I think the response there is because the records relate to Oasis business and not to Hartnell business. And so Hartnell is not in a position to assess whether any exceptions to disclosure might apply.
And I would add to that, accept the liability that would go along with that if decided incorrectly, or if there were any question. So tell us what your response is to that, those two issues.
A couple of points on that. One, Oasis has the ability to come in with a mark in action to, as a third party, say, we have an interest in these records and they should not be disclosed. Oasis has not done so. It knows about this case. It could have done so. It chose not to. It presumably knows about the content of those records, and perhaps knowing what those records contain is not concerned about it and has no objection to their disclosure. That's a question that we haven't even been able to evaluate in this case while we debate the issue of whether they are public records in the first instance. As for the liability, Hartnell has no duty to the individuals in question whose ever private information is contained in these emails. Oasis is the one who allowed the disclosure to a third party, here Hartnell, and did nothing to correct it. We have the executive director or the superintendent or whatever the top official is called at Oasis communicating with Navarez, using Navarez's Hartnell email account, knowingly and willingly exposing whatever private information is contained in those emails to Hartnell. From Hartnell's perspective, it is knowingly and willingly allowing its employee to expose it to liability by engaging in a substantially more than de minimis use of Hartnell resources.
Well, except
Hartnell-
from a management perspective, in what way would a manager be able to determine that anyway, unless you're snooping into everybody's emails all the time, which most unions are not going to be enthusiastic about, to say the least. I mean, and most public entities are unionized, so that's Mr. Martinez raises a point there. So this gentleman, Navarez, might very well have engaged in more than de minimis use, but I'm not certain that it's reasonable to place the responsibility for that on Hartnell. What's your response there?
If that's the case, then my first point about Oasis stands in that Oasis is the one responsible for keeping that private information secret, and it allowed that information to be disclosed to Hartnell. It should have kept better control of that information by requiring its employees to conduct Oasis business using Oasis email resources. And by failing to do so, it has opened the door to its liability there, immunizing Hartnell from any liability in fulfilling its legal obligation, especially if ordered to disclose the records by a court. I don't see how, in response to first a public records request and then a court order to disclose records, supposedly, because the issue here still is the threshold question of whether they are or are not public records. If the determination is a conclusion that they are in fact public records, perhaps Oasis may be able to come in a Markin fashion and look at those records before they are disclosed and evaluate the potential exemptions once the determination has been made that they are public records. It's putting the cart ahead of the horse a little bit, but there are ways of resolving that problem if it is in fact a problem. And I think it's premature to accept the fact that it is, because Oasis, as I mentioned, has been on notice of this request and this action and has declined the opportunity to intervene and assert whatever rights it wants to assert.
So, Mr. Morgan, we asked you quite a few questions that I think moved you off of points you wanted to make, and we're interested to hear what you would like us also to know, because that might also raise additional questions. So you go ahead, sir.
I guess one point I wanted to circle back to, it was mentioned in our briefs, but mentioned during petitioner's argument about the timing of when charter schools became subject to the Public Records Act. There was an Attorney General opinion, which itself is not binding law, but it interpreted already existing law that concluded that charter schools were in fact subject to the Public Records Act. A significant aspect of petitioner's argument was that the legislature had considered expressly requiring charter schools to comply with the Public Records Act and refused to do so. The Attorney General correctly noted that those proposed bills and legislation did much more than subject charter schools to the Public Records Act. But it seems pretty clear that the records relate to the conduct of the public's business, as it relates to Oasis in the first instance, but also to Hartnell, as we have mentioned. And petitioner did not have an opportunity to address the other issue in this case, but if the court doesn't have any further questions about the Oasis emails, I would like to move on to the disciplinary records.
All right, you go ahead.
Without anything specific to respond to from petitioner's argument, but considering the reply brief that was filed, I note that petitioner continuously refers to high-ranking employees as having a different category of privacy as opposed to more rank-and-file employees. And in the real party's return, we focused on high-profile. High-profile is a term used in Markin. In the reply brief, petitioner inferred that Markin was misrepresenting BRV, and that the BRV v. Superior Court case focused on high-ranking rather than high-profile. The term high-ranking doesn't appear anywhere in the BRV case. And just want to look at Markin for the three paths described in the real party's return that could lead to disclosure of disciplinary records. And that three-path test that the real party articulated was extracted from Markin's discussion of all of the cases that preceded it, including BRV versus Superior Court, the Associated Chino Teachers case, the Bakersfield case, and others. And in each of those cases, it establishes a framework for balancing the employee's privacy interests versus the interests in disclosure, where high-profile employees, regardless of rank, have a reduced expectation of privacy, not all that inconsistent with the discussion in International Federation, which related to public employee salaries. These high-profile employees, if there's disciplinary records relating to them, they're going to be disclosed because they are so high-profile that the public has a greater interest in their disciplinary records than the employee has in maintaining privacy. And I talk about employee interest in privacy, but an important consideration under the Public Records Act is that it is the public's interest in preserving the employee's interest in privacy. This is not kind of like a Hill, the Hill, I think it's versus collegiate sports, or the kind of the seminal case on privacy interests. This is not that type of privacy interest, because we're also considering the public's interest in disclosure under the Public Records Act. Working our way down, if a complaint is well-founded and substantial, of course that heightens the public interest in disclosure regardless of the employee's rank, as is the case also when there is actual discipline. And I think went over all of this in the return. I just wanted to focus specifically on petitioner's discussion of Markin and respond to that here. And unless the court has any further questions, I would submit.
All right, thank you, Mr. Morgan. I'm not hearing questions from my colleagues, and I don't have any further questions at this time. Let's hear from Mr. Martinez. I'm going to give you about 3 minutes because we really run substantially over, so.
Absolutely, Your Honor. I just
Okay,
want to
thank you.
address some of the points in rebuttal. Number one, I think that respondent is talking about a lot of things that are not in the record. For instance, this question about the de minimis use. Number one, there is no evidence in the record that challenges the de minimis use of that. In fact, quite to the contrary, there's a declaration of the superintendent, Raul Rodriguez, that clearly explained that there's a policy and that the complaint specifically on the de minimis use by this employee was found to be unsubstantiated. Number two, I think council's talking about a lot of what's in the mind of Oasis. I don't know where in the record Oasis was notified. I don't know anywhere in the record where Oasis denied to be here, didn't want to be here. This was something that was argued at length down at the trial court where it should have been respondents, or not respondent, real party and interest's obligation to make Oasis an interested party. They chose not to, so I'm not exactly clear as to where Oasis seemed to know how this was going to happen. When he said that it would be easy to give Oasis a mark-in notice and my client, or I'm sorry, the district would end up just getting immunity from Oasis, there's a fundamental problem with that. In order to get that immunity, they're paying a lawyer to then file paperwork, go into court, ask the court that we are immune, ask the court to give us a get-out-of-jail-free card from the liability. By that time, my client is already spending treasure on trying to do that. So this is not inconsequential to just simply throw out there that Oasis would magically indemnify us. I'm not even sure as a corporate entity whether or not Oasis has, it's not a governmental agency. It doesn't even have their resources backed by anything real like the government. That they're a corporate entity that can go bankrupt at any time. Charter schools have gone bankrupt. The last thing I wanted to say with regards to cause of action number 2, there was a concession made by respondent in his return on page 33. He concedes that the wrong test was applied by the lower court, that there is no such relatively high-ranking test. The organizational chart that was provided in the record, as well as the declaration, says that the employee is a mid-level employee. He is entitled to the protections of Markin, which is whether or not the complaint was substantial and well-founded. It doesn't meet the well-founded prong. It was unsubstantiated. Those claims were looked at by the community college, and there's no there there.
Does that require us to resolve the conflict between Mr. Rodriguez's declaration and Mr. Sandoval's in Hartnell's favor?
I think it does for 2 reasons, Your Honor. I think that there's not a lot of dispute about the facts. Mr. Sandoval's declaration is something to akin of, well, Mr. Navarez is the dean of students and he gets a lot of face time with the public. So a lot of...
Just for clarification, I was referring more to the letter from Hartnell to Mr. Sandoval talking about, thank you very much for bringing this important issue to our attention, and we've taken care of it. Appropriate action will be taken. It's not going to happen again. I'm not quoting exactly, but it certainly suggested the taking of appropriate remedial actions in response to the findings of its investigation.
I encourage Your Honor to take a deeper look into that letter. You will find that the letter does not state that discipline was imposed or that the employee was found of any wrongdoing.
What's appropriate remedial action then?
I think that it's that the policies will be followed and that members of the public are entitled to make complaints. They say, hey, I think something's wrong. Doesn't mean that they're right. They say, I think something's wrong. The governmental agency looks into it and then has a responsibility at some level to report back to the person making the complaint. I think in this instance, coupled with the declaration that revealed there was no there by the superintendent and there were 2 declarations filed in this matter by the same, to the same conclusion under penalty of perjury, which is not the same thing as the letter, you will find that that letter explains to the community member, look, you thought there was some nefarious business going on. There's no nefarious business going on. Thank you very much for your concerns. Have a nice day. I don't think that there's anything in there that says Mr. Navarez committed some terrible sin, Mr. Navarez was given 50 lashes for this or that. There's nothing to that effect. And I think that those 2 declarations in evidence absolutely do stand up as substantial evidence, and there's no evidence in the record, which qualifies as an abuse of discretion. There's no evidence in the record that says that this conduct rose to the level to meet the Markin test. And the last thing I would say is that I think counsel may have misspoke. I don't think Chino Valley was addressed in the Markin case. It fell many, many years after Markin, but the point being is that Markin set forth the test for everybody else. Chief executive officers, you have a diminished constitutional right to privacy, a diminished constitutional right to privacy there because of the responsibility that you hold, not because of how many people come across your desk, not because of how many phone calls you answer or how many members of the public you shake hands with. It's the responsibility that goes with that chair that the court was concerned about and said because of the responsibility that comes with that chair and only that chair, you have a reduced expectation of privacy. And in those rare situations, we will allow unsubstantiated claims to go forward in certain circumstances because the public ought to know. But for everybody else, we're going to proceed with the Markin test where you have the 2-prong test. And because Mr. Navarez does not even fall on the OR chart, he's neither the chief executive officer, he's not the executive level cabinet member, he's lower than low. In respondents' pleadings, he says, well, he even reports to somebody who's kind of important. You don't get coattails of importance. You don't get to say, well, you know, just because he sits on that person's coattails, they are now somehow important. And therefore, now he has a diminished expectation of privacy. On that, Your Honor, there's not any other questions. I respectfully submit.
All right, thank you very much, Mr. Martinez and Mr. Morgan, for your very helpful comments today. It's obviously a case of interest to the court. Before we leave, Mr. Morgan, I simply have to ask you, where is your background? What are we looking at?
It is a stock photo I found on the internet.
Oh, I knew that, but I meant, does it portray a particular place? Do you know?
I'm not sure, Your Honor.
All right.
It just seemed appropriate for the circumstances.
Yeah, a lot of wooden seats. So, all right, thank you very much, Mr. Martinez. This matter is now taken under submission. You will have a written opinion within 90 days. Thank you very much.
Thank you.